Welcome to the final installment in the webinar series titled Enhancing the Value of Growing Private Equity Platform Companies via Proactive Compliance Initiatives. Today's program will address and provide guidance on employee benefits and executive compensation, compliance, and planning. Before we begin the presentation, please note that today's webinar is being recorded and participant phone lines will be placed on mute throughout the program. You're welcome to submit questions directly to the presenters during and after the webinar. In 2 to 3 business days, Epstein, Becker, Green will email registrants a link to access a recording of today's program and PowerPoint materials. Joining us today are 3 Epstein, Becker, Green attorneys. Christopher McMican is a member of the firm in the Employee Benefits and Executive Compensation practice. He focuses on assisting and advising employers with issues including ERISA compliance, retirement plans, health and welfare plans, executive compensation, fiduciary matters, phantom and equity plans, stock options, and all elements of the compensation package, as well as corporate matters. Kevin Ryan is also a member of the firm in the healthcare and life sciences practice. He advises for-profit and not-for-profit healthcare clients on transactions and regulatory matters, including licensing laws, HIPAA, privacy requirements, and state and federal administrative matters. He also counsels businesses on mergers, acquisitions, and joint ventures. Peter Steinmeyer is a member of the firm in the employment, labor, and workforce management practice. His experience includes advising clients on the enforcement and drafting of non-compete, non-solicitation, and employment agreements, and on movement of employees between competitors. He has also provided counsel on workplace discipline and discharge, policies and procedures, and accommodation issues under the Americans with Disabilities Act and the Family and Medical Leave Act. At this time, I'd like to turn the presentation over to Chris.
Thanks, David. As David mentioned, we're going to talk a little bit today about the employee benefits aspects of the transaction. And I'd like to start out with a little bit of an overview of what I'll cover. And so essentially, we're going to start out with understanding the groundwork for the transaction, what type of transaction it is, who's involved, stock, assets, employees, nuances for the business and that type of thing. We're going to talk about what type of plans or arrangements might be coming over from the seller that the buyer might inherit. We're going to talk a little bit about due diligence, a little bit about the purchase agreement, some issues that might come up in terms of the employee benefit plans and what possibly a buyer might do about them to address the issues. And then we're also going to think about some going forward planning, because the closing of the transaction isn't the end of the transaction. So we'll think about what we're going to do with any seller plans that might come over to the buyer. So then after I'm done talking, I'll turn it over to Kevin, and he'll talk about some related issues for the transaction. So with that, I'd like to jump in and talk about the groundwork for the transaction. Whenever I'm looking at a transaction from an employee benefits perspective, there's 2 things in my mind that I always think about before I even get involved. One is, what type of business is being acquired? And this is especially important in the healthcare industry because you're going to get some different types of employers, sellers, employees, license issues, things like that, that could impact employee benefit plans more so than you would if maybe a manufacturing company was going to get acquired. So it's important to ask those questions up front, figure out what exactly the seller is, are there unions involved, collective bargaining agreements, that type of thing, because that'll really influence the due diligence you do, and we'll talk a little bit more when we get there. So the second thing I always want to know, this is really probably as important or more important than the first, is are we buying stock or are we buying assets? And that really makes a huge difference because it really dictates the type of due diligence, the level of your analysis of the plans and your planning. Because, of course, if you're buying assets, and buyers often like to buy assets because they don't always take all of the liabilities or the plans, you still have important work to do, but it's not quite as important as if you are buying stock, because then you're probably getting all of the assets, all of the liabilities, and all of the employee benefit plans. So that'll take care of the first slide. With that, I'd like to go into, what exactly is coming over. So we have to understand, what does the seller have and what possibly could we as the buyer inherit? So it's as simple as really getting a handle on what plans and arrangements are out there. You might think of 401k plans, 403b plans, standard health plans for employees that include dental, vision, all of those niceties. There's deferred compensation plans often. And I think the one issue that goes by sometimes without being noticed is that there's those deferred compensation promises or arrangements that are often in employment agreements, side agreements, offer letters, things like that, and they're very important to make sure that you take a look at those. The other key part I wanted to say before we leave this slide is there could be a traditional defined benefit pension plan or a multi-employer defined benefit pension plan, and it's very important to, from the outset, figure out what the seller has there, because not only are those standard tax-qualified retirement plans, but they have the capability to be a big-ticket liability item, because oftentimes the seller may not have funded the traditional pension plan. If they're in a multi-employer plan, there could be what we call withdrawal liability, meaning that if there's a corporate transaction, it might trigger a withdrawal event and a big tax bill or a funding bill to go along with that for the seller, which could be inherited by the buyer. So the moral of the story is always ask if there are traditional pension plans or if there's any participation in a multi-employer plan. So with that, we'll go to the next slide and we'll talk a little bit about due diligence. So I put this slide in and I put the exclamation point on the title because it often happens that the employer sometimes calls and says, oh, the transaction is going to close in a week or two, and I always say, well, what due diligence have you done? And sometimes they've done a little bit, sometimes none. So it always pays to spend a decent amount of time on due diligence, and you should always do it early in my mind, because you never know what's going to come up. You never know if you're going to have time to look at further documents, ask questions. So when you get involved in the transaction, always look to see if there's an electronic data room where documents are posted, and start looking at those right away in terms of every benefit plan. Look at the employment agreements, look at the offer letters if there's a promise maybe of deferred compensation in those. You're really looking for compliance and risk points. So how well have those agreements been carried out? Are they legal? Are they compliant with the deferred compensation law known as 409A? If they're not, then those problems have to be addressed right away. The other thing to think about when you're looking at these is think ahead for integration, because at some point the deal is going to close, and when the deal closes, you've got to think about, are these agreements going to carry on with the buyer after closing? Are the employees coming over? Are there any payouts triggered? Do we need to rewrite these agreements? How does all that work? So you'll look at that in the due diligence, and you kind of figure out, okay, where are we going to go from here? So, and I've been focusing a little more on the deferred compensation and the benefits aspects, but Pete, from your perspective as an employment lawyer, do you have any thoughts on due diligence in terms of employment agreements?
Sure, thanks, Chris. So, as an employment lawyer, I see these things a little bit differently when I'm brought in on a transaction. One of the most valuable assets, if not the most valuable asset that most employers have, is the talent of their workforce. And so the question that I always look at, and what I focus on, is the workforce going to stay? Can you compel them to stay? Are there incentives for the workforce to stay? So I will look at things such as, are there existing non-compete agreements or garden leave agreements? If there are existing non-compete agreements, are they enforceable given all of the changes in the law, given the change in corporate structure stemming from the transaction? Will those agreements actually be enforceable? If not, do you need new ones? If you need new ones, what is going to be the consideration for them? I also look at incentive compensation ties that would tie in the workforce and help to maintain the workforce. So I will look for things like, are there incentive compensation plans already in place? Are there, stock option plans, deferred comp plans, things like that that will help to retain the workforce, but also can be triggers for liability in relation to a transaction. So I look at it both ways. Both, will the transaction trigger liability, and will there be an intact workforce after the transaction? I also look at things like offer letters, severance agreements, relocation agreements, any sort of agreements that employees may have with their employees. You want to know about those before the transaction closes. And in the healthcare context, and Kevin will be talking about the healthcare context next, I will look at the compensation arrangements with physicians, which can be phenomenally complicated. Sometimes their agreements are so complicated that the only person who can ever figure out what a doctor is entitled to be paid is the accountant. But again, if you are the acquirer, you want to know what you're going to be getting into, what you'll be paying the workforce, and you need to know in advance. So those are all things that I look at from the standpoint of an employment lawyer.
Thanks, Pete. So we'll move on to talk about the purchase agreement in the next slide. So at this point in your review, you've basically got your arms around the background of the transaction and who's doing what and who's involved and the nuances of the deal. So now it's time to talk about the purchase agreement. And the purchase agreement is a very important document. And from an employee benefits perspective, there's a couple of areas I focus on. Usually there's 2 or 3 sections in the entire purchase agreement. You've got your representations and warranties, and that's really the seller telling us what they think about their plans. Are they perfect plans? Are they in compliance in all respects? So it's really important to not only read those, understand them, make sure the language is strong enough and that you're satisfied that the seller has good plans and that you're not going to inherit a plan with all kinds of problems and potential penalties. One interesting point is, this seems to come up in many transactions, we often argue about the knowledge standard, and in those purchase agreements, the seller typically wants to insert a knowledge standard where they say, our plans are great to our knowledge, and we don't have any knowledge that there's anything going on that's bad. So, and the buyer always wants to eliminate that knowledge standard so that the seller is held to a higher standard. So that's usually a little bit of a push and pull. You can see what happens. So the last point I wanted to make on that bullet there is, make sure that the seller is required to produce all their documents. Think about how many years of documents you want to see. Is it 1 year? Is it 2 or 3 years? That's usually standard in the industry. Covenants, those are covenants. Promises going forward. Is the seller requiring the buyer to do anything after closing? In other words, provide our employees with X, Y, and Z. Full vesting in a plan, maybe. The same matching contribution that they had, the seller, things like that. Sometimes those are reasonable promises, but sometimes they can be difficult to incorporate. And the last point I wanted to make in this slide was indemnification provisions are interesting because oftentimes the buyer says, well, we've got issues here. How much is the seller on the hook for later if we have a compliance cost to this with an employee benefit plan? It might be an IRS cost or something like that. My personal thought is it's difficult to rely on any indemnification bucket, as sometimes they call it, which maybe hangs out for 6 months or a year before all of the dollars from the transaction go to the seller. And sometimes the buyer can dip into that, but now you're making a claim. There might be a deductible before you really see anything. So my only point there is you really want to not probably rely on the indemnification bucket. I've seen some buyers obtain rep and warranty insurance, but that's a little bit more difficult to get. So just beware of indemnification provisions and how useful they are. I don't know, Kevin, do you have any thoughts on indemnification from a corporate perspective?
Sure. I mean, we see them frequently in almost every healthcare deal that we do. The important thing about indemnification is one, you have to meet certain requirements in order to get the indemnification in the first point. And then you have to, prove that you're meeting all of that when it comes time to apply. And I've seen, especially when people try to invoke the indemnification language, that, the seller will argue that, oh, this falls outside of the indemnification, or it doesn't meet the standard, or you end up having to litigate it, which costs a lot more. So I agree with you. I think it's best to do your due diligence up front. And you also mentioned rep and warranty insurance. The thing there is that you've got the insurer is going to be doing due diligence as well to make sure that whatever they're insuring over the reps and the warranties, that you've investigated those and that you're comfortable with them, because they're going to want to make sure that they're protected as well. So, I mean, it's like a double layer of diligence, but you better make sure that you've at least looked at it, because the rep and warranty insurer is sure going to ask you.
Thanks, Kevin. So with that, we'll move on and we'll talk about what happens if you encounter a problem with the employee benefit plans or arrangements. It doesn't mean that the deal's over, because, as we all know, nobody likes the employee benefits lawyer that kills the deal. So with both retirement plans and health plans, you're really looking for plan document issues. For example, amendments. Are there required amendments that have not been made over the last few years? You're looking for operational issues. Was the plan administered in a way that was inconsistent with the plan terms? And just general legal principles that might apply. For example, in the health plan world, you'd want to think about the Affordable Care Act, COBRA, HIPAA, all those types of things that need to be compliant for a plan and may or may not be. So if you do find a problem, there are certain things that can be done in addition to just maybe adjusting the purchase price. And what I mean by that is there are IRS and DOL correction programs that can be used to get a clean bill of health for the plans, and they require a little bit of work and some submission sometimes, although sometimes you can self-correct as well. So always think about and investigate those types of corrections, and it might just be something that will save the deal. So with that, we'll go to the next slide, and the same sort of thought process works with executive compensation arrangements. And again, don't forget to look in the employment agreements, the offer letters. In the IRS's mind, those are plans, and if they have an element of deferred compensation, still has to be compliant. Got to look at Code Section 409A, which is the law that governs deferred compensation. It has severe penalties for it. There are correction programs for 409A violations, but they're not as broad or flexible as the ones, for example, for tax-qualified retirement plans like a 401k plan. Last point I wanted to make in that slide is, again, thinking about going forward, what about equity plans that might be in place? Are there promises for new equity grants or awards or payouts that maybe were either granted before closing and might come to fruition after closing? Got to take a look at those things, because you might have to provide some sort of workaround for those types of things. And with that, we'll go to the next slide. So now the transaction is over, and we're thinking about, well, what happens now? What do we do with these employee benefit plans? Lots of things could happen. You have to ask yourself, are these plans going to terminate at all? If they terminate, would they terminate prior to closing? Would they terminate after closing? What happens with the employees? Are all the employees coming over? Are they going to expect to get their same benefits that they had pre-closing? Should we think about merging the plans from the seller? For example, their 401k, should we take the assets into the buyer's plan, simplify things, and have one plan for everybody? All of those things need to be considered, and all of those things have various consequences in terms of how the plans are tested and how whether they're going to be compliant and how they're going to function. Also think about employment agreements, those that may or may not contain deferred compensation. What happens with those? Do they need to be assigned and transferred? Do we have to prepare new agreements? What happens there? And Pete, I'll ask you from an employment lawyer's perspective, do you have any additional thoughts on that?
Well, with respect to, assignability or transfer of employment agreements, I would just say that you need to be aware of the corporate formalities, which entity actually entered into the agreement, which entity will be the employing entity after the transaction. Will the employing entity be the legal successor or not? Sometimes there's the employer of record can be different than the acquiring entity. And so these are just things you need to think about. None of these are insurmountable hurdles. They're just things that you need to think about when you are structuring the deal. You may need, for example, an assignment and assumption agreement. Non-compete agreements will flow as a matter of law to the legal successor, almost as a matter of course. However, in an asset deal, it's not necessarily the case unless you're acquiring all or substantially all of the assets. If you're only buying a portion of the assets, I would not assume that a non-compete is going to flow with that. So these are just, none of these are insurmountable things, but again, they're just issues to be aware of and to give some thought to.
Thanks, Pete. So we talked a little bit about the middle 2 points there in terms of transitioning plans and the testing that's involved and the various considerations that will go into the thought process of moving forward after closing. The last point I wanted to make there, and I think Kevin will talk a little bit about this, but there's an interesting issue you often see in the healthcare space where there may be related entities where a physician may own a PC and there's a management company, and certainly that is practical, but it also presents a few issues that you have to navigate for employee benefits when you're talking about 401k plans and health plans, because you need to determine whether they're an affiliated service group or a control group, and that'll determine how those plans can function, how they're tested for discrimination and things like that. So if you see that set up, hopefully that'll trigger in your mind that issue is there, and somehow you need to think about that and what that planning could entail. So with that, I'll turn it over to Kevin.
Thanks, Chris. On the corporate practice, we're gonna continue on. We'll talk about some corporate practice of the professions, overview and best practices. First of all, addressing some corporate practice of medicine risk, the overview of a compliance structure, maintaining the separate identities of a management company and a professional corporation, engaging in the due diligence process on the healthcare side of things, and then integrating providers following that healthcare transaction. So on the next slide, thanks. The corporate practice of medicine risk. For many of you on the webinar may already understand about the prohibition on the corporate practice of medicine, but the corporate practice of medicine, there are several states, many states actually, have a prohibition on a general business corporation engaging in the practice of a licensed profession. So it's frequently grouped under a heading called corporate practice of medicine because medicine is the most common profession where this prohibition applies. But it is a state-specific and a profession-specific prohibition. So there are some states like New York, which actually has a corporate practice prohibition on nearly all licensed professionals. And then there are some states say Delaware, Louisiana, where they may only have a prohibition related to one profession, optometry in those instances. And there are other states, California, Illinois, where there may be a prohibition on some, but not all. California, Illinois both have prohibitions related to medicine as well as psychology, dentistry, but say nurses, nurse practitioners can actually be employed by general business corporations. So what do you do in those states if you're going to be involved in a transaction where there is this prohibition and a general business corporation can't come in and acquire a professional entity? In that case, we set up a structure which is called this friendly PC or captive professional corporation structure. And that involves a professional entity which is owned usually 100%. You usually have a small number of owners in a friendly PC structure by a friendly professional who may have some relationship with the business corporation. They may be a medical director, or may have been a founder of the business corporation, and then that professional corporation is then managed by the non-professional entity. And these management companies are frequently referred to as management services organization. The acronym MSO is frequently used, so you may see that as well. And the professional entity and the management services organization are then aligned through a administrative management services agreement. That agreement, which is usually pretty extensive, describes the parties' responsibilities to each other. Usually it's set up so that the manager is responsible for all of the back of the house or business decision related to the professional entity, and then the professional entity itself, the practice, is responsible for all the professional and clinical decisions. It's very important to maintain that clinical independence in the professional organization, so the management agreement usually makes it very, very clear that the management company is not making any type of clinical decision making. And then the management entity and the professional entity do work together, but it's important to understand that they are separate legal entities. They have separate tax ID numbers, and they have different responsibilities and authority. On the next slide, the compliance structure. As I mentioned, it's important in the professional corporation MSO structure to make sure that clinical care, the professional services, maintain their independence and decision making. So you want to make sure that if you're going to have a transaction where you're going to employ the professionals, licensed professionals, that the professional organization is the one that's actually entering into those employment agreements. We've been involved in transactions before where some people who may have these types of entities aren't really familiar with the prohibition. They may have set it up and didn't really get a lot of guidance on the proper structure, and so post-acquisition you may be having to set up a professional corporation and making sure that the employment agreement is then with the professional entities. It's also important to understand when you're doing this to know which professions you can employ or you can't employ. So nurses in some states can be employed by general business corporations, but there still has to be provisions in those employment agreements that state that the business corporation cannot interfere with the professional decision making of the licensed professional, and that the professional's decision making when it comes to clinical care is theirs and theirs alone, and the management company can't get involved in the middle of that. There's usually provisions in the management services organization where the MSO will try to seek consensus with the professional practice over all kinds of things. That usually includes clinical protocols, scheduling, fees charged by the professional services. Many states actually state that the management services organization cannot set the fees of a professional corporation, and also shouldn't be involved in the scheduling. So although these things may seem like why wouldn't the management company, if it's running a business, get involved in the scheduling and the fees? It's important to understand that there are several states that have decided that kind of decision making by the management company is actually interfering with the professional judgment of the licensed professional. And then, as I mentioned, in the states with corporate practice prohibitions, the professionals must be employed by the professional corporation. As Chris mentioned, we do see particularly as companies start to roll out, telehealth companies in particular, or entities that may be involved in bricks and mortar services, but across multiple state lines, the decision as to whether to set up different PCs for each state, or perhaps they set up a professional corporation and then they will foreign qualify it in other states. Either one of those models really depends upon the goals and the needs of the individual companies. But when you have multiple professional corporations across the states, and we've even seen clients who have multiple professional corporations even within one state, the issues that Chris mentioned about making sure that the benefit issues and are they now affiliates of one another, or how do the benefit plans interconnect, becomes very critical to look at up front, because if you don't look at it at that time, sometimes the structures are put in place and you didn't realize that all of the benefit issues can be a complicating factor as you're trying to implement the structure that you've chosen. On the next slide, just wanted to point out that it's very important, as mentioned before, to the professional corporation, the management company, maintain these separate identities. Again, they should have separate tax ID numbers. That it should be very clear that the management company is the management company. It shouldn't say that it's doing business as the practice. The stationery of the management company shouldn't really be the professional corporation's letterhead or stationery. That should only be used by the professional corporation. Many times we've seen management companies that want to say that that they're employed by the practice, or they may have email signatures or business cards that actually have the name of the professional entity. Again, it's important that the management company should be presenting itself with information as to the entity that actually employs those management company employees. Even though it may complicate things a little bit, you just want to make sure that everybody who's working with the practice knows that the professional entity is the practice entity, and the management company is providing those management services, and that's how it should be presented. And if you have to explain it a little bit to people, that's what you have to do. You can't try to just say, well, people aren't going to understand this, or it's a complicated structure, so we just use the practice's email or the practice's business cards. And it's also important to note that the management company's employees should not be supervising, overseeing, directing, or controlling the practice employees outside of certain things, related to maybe how they put some information into the electronic health records or something like that. But the management company should not be hiring the employees. They should not be firing practice employees. Those decisions all have to be done by the professional entity. Now, the management company can assist, and that's fine, but it can't actually do the hiring and firing. Maybe it does the recruiting. Maybe it assists the practice on how to terminate an employee, but again, it should not be doing the actual employment. Again, it's very important that they're not supervising or directing. There have been Attorney General opinions out there in some cases where the Attorney General believed that some management company employees had too much control in one case over dental practice, and so they made sure that the management company made representations that it would restructure so that kind of supervision was no longer allowed. The next slide. As Chris already mentioned, in engaging in the due diligence process on the health side of things, it's always pretty much the same as some of the things that he mentioned. You've got existing agreements. Because of the professional corporation structure, you may actually have agreements with the same people in multiple places. Employment agreements. There could be some things in the management agreement. There may be documents where you purchased a practice, at least the non-clinical side of the practice, and so you've got a purchase agreement. And there may be some supplier agreements. Maybe you're actually leasing them space or providing equipment as well. Then there may be proposed agreements, as I mentioned, purchase agreements, there's the management agreement we discussed, and there may be employment agreements. And because of the corporate practice structure, you can actually have employment agreements with both the management company, where it's possible that the employee, the professional employee, provides some administrative services to the management company, and so therefore has a direct manager or contract employment agreement with the management company, but also provides professional services and therefore has an employment agreement with the professional entity as well. And again, it's very important when you have those types of agreements to make sure that one is for administrative services and one is for professional services only. So on the next slide, as we're already mentioned, there may be covenants that are being entered into. There could be restrictive covenants. There can be non-solicitation covenants, other type of restrictive agreements, and they could be in the purchase agreement, which may restrict a certain type of activity. There may be in the employment agreement. They could be in both agreements. Again, and it's very important to understand and work with counsel to see what's allowed. So if we go to the next slide, because the provider contracts can be with licensed entities, they can be with professional corporations, and they can be with management companies. They can be with sellers. And so each one of these may have different issues. I think that, Pete's already mentioned that restrictive covenants can be a state-by-state analysis, and it can be a profession analysis. So doctors in Texas may have a buyout right, where a doctor doing the same service in Illinois may have they may be allowed to be restricted from practicing if the time limit and the geographic restriction are both reasonable, but maybe only after a certain amount of time has passed for that doctor to have provided services. Other states may have, California may have a restriction completely, except for in cases where you actually purchase the practice. So again, it's important to understand when you're doing these deals, where you're doing it, what profession you're working on, and what may be allowed and not allowed. It also may impact how you decide to structure it. If you want to put the PC in California, or if you want to put it in a state where certain other restrictions may be available and may be enforceable, where maybe it's not in California and you just chosen California law to be the law that was going to cover that or govern that contract. If we go to the next slide, there are, if restrictive covenants are not permitted, there may be things that you need to look at. So are there less restrictive alternatives? Sometimes it's not allowed if it's a certain time distance or time or distance requirement. So you may be able to shrink the restriction. If you're trying to restrict somebody from practicing the entire practice of medicine, perhaps it's that they will only be restricted from practicing telemedicine, but would be allowed to practice medicine. So you'd have to see if there are less restrictive alternatives. Maybe the restrictions could be limited to just certain competitors so that they're not outright prohibited from providing services at all. And then restrictions to certain activities. As I mentioned, it may be providing telehealth services. It may be acting as a medical director to an organization. or it could be restrictions limited to just other management companies, which may not be related to the practice of a profession at all, but providing administrative services similar to what the management services that the professional is providing to the MSO. But Pete, you're the co-chair of the firm's non-competes and trade secrets practice. I mean, do you have any thoughts regarding due diligence related to provider restrictive covenants?
Well, one thing just to be very sensitive to is that the law is evolving in this area on a state-by-state basis across the country, but generally speaking, it's evolving in a way that is opposed to non-competes and is opposed to restrictive covenants. Courts increasingly are looking for reasons not to enforce these agreements. So you just, you need to be very aware of what state you're in, what restrictions there are in that particular state, and you need to be aware of developments in the law in those states, and you need to be aware of the impact on defined terms within the agreements of changes in corporate structure. You'll have defined terms, what's a competitor, what's the business, and all of these things may change significantly following a transaction. So you need to be aware of all of these things when analyzing the likelihood that a court would actually enforce a restrictive covenant. And Kevin raised a terrific point about looking at less restrictive alternatives. And, there are other alternatives that I'm encouraging my clients to look at as opposed to your traditional non-compete agreement. Those could include things such as garden leave clauses, which is essentially are just advance notice requirements, requiring that the employee give 30, 60, or 90 days advance notice that they would be leaving, and during that period of time, they remain an employee. You pay them. You can tell them to, go home and tend to their garden, but they remain your employee, and because they are your employee, they owe you a duty of loyalty, and they can't compete with you. Something else you can do is have a paid non-compete period. A court will be much more likely to enforce a paid non-compete period where you're paying somebody to sit out for a period of time than they would to enforce a traditional non-compete. Something else that you can do is have what we call employee choice clauses, where basically it's the employee's choice. If you want to compete, fine, but if you do that, you're going to forfeit the following compensation. So there are alternatives, but the key thing is just to be aware of the sort of overall judicial hostility to non-competes and the changes in the law in this area, and you just really need to be sensitive to those issues. If you really care about them and you really think that you might want to enforce them, just know what the likelihood of enforceability is in advance.
Good.
So it looks like we've got a question that came in, and I think it's for Pete. It says, from an employment lawyer's perspective, what's the biggest surprise that you've seen a buyer have post-acquisition?
The biggest surprise that I have seen is in the area of withdrawal liability. Sometimes, corporate counsel may not necessarily be familiar with what withdrawal liability is, and it can hit the buyer as a big, unexpected liability post-transaction. Essentially, withdrawal liability is if an employer either stops contributing to a multi-employer pension plan or significantly reduces its contributions. And these things can happen following business changes, slowdowns of business, or even corporate transactions. Any of these things can trigger withdrawal liability, and what withdrawal liability is essentially a proportionate assessment of the amount by which the multi-employer pension plan is underfunded. So you can get hit with this liability completely out of the blue, and I have seen employers be extremely unhappy when they find out that they are potentially facing this after the fact. So that's something I would just tag as an issue. You definitely, if you've got a unionized workforce, you need to have experienced labor counsel or experienced benefits counsel just take a look at this and make certain that that's not a liability that's lurking out there.
I've seen a number of situations like that where the business owners don't even know about the concept of withdrawal liability.
Right.
And when you tell them that, hey, it costs money to leave the game,
yes,
why would I have to pay to leave the game? And it's an odd concept, but it's there. So.
Yes, and sometimes even corporate counsel themselves may not be that familiar with it. It's an oddity. I mean, I'm not an expert in it. I know enough to spot the issue and know that it's out there, but it's a very unusual concept, but it's a serious one, and you just need to be aware of it. Do we have time for one more question? Oh. Okay, I think, David, I believe that we're now out of time. I know that there's some other questions we were unable to get to. If any of you all have follow-up questions, feel free to reach out to me or Kevin or Chris, either by email or phone. We'd be glad to talk to you about any questions you may have.
Thanks, Pete. This concludes today's webinar. A reminder that in 2 to 3 business days, Epstein Becker Green will email registrants a link to access a recording of the presentation and PowerPoint materials. Thank you for attending.